Constance Marten and the Predator's Grip. Hello, I'm H.G. Tudor. Constance Marten and her partner, Mark Gordon, have been jailed for killing their newborn baby. They were both convicted of the gross negligence manslaughter of baby Victoria following a lengthy and chaotic retrial in July this year. They were also found guilty of child cruelty, perverting the course of justice and concealing the birth of a child. They were each sentenced to 14 years in prison. This is an interesting case involving the tragic death of a child. It is interesting because on the one hand, you have a woman, the mother, who comes from society, from a privileged background, who has become involved with a predatory individual. I'm going to analyse the circumstances of their case, their backgrounds, and what this tells us in relation to what each individual is, and moreover, what happened to cause the two of them to act in the way that they did that resulted in the death of a child. My starting point for this is to take you through the sentencing remarks of the judge, because this provides you with a useful background of what happened in the case based upon the facts as determined at trial. The information contained within this allows you to understand the factual matrix, along with certain findings that have been made, which will then be utilised with additional background information into the lives and histories of both Constance Marten and Mark Gordon. These are the sentencing remarks of the judge. On Monday, 14th of July 2025, at the end of a lengthy trial, you were both convicted of killing your baby daughter by gross negligence manslaughter. On 23rd of May 2024, in the first trial, another lengthy trial, you were both convicted of concealing the birth of your daughter, perverting the course of justice, and child cruelty. You must now be sentenced for all these offences. Pausing there. The two defendants were convicted following trial, which demonstrates that they entered not guilty pleas, which demonstrated that they did not accept that which they were accused of, but they were found guilty. This demonstrates a failure to accept accountability for their behaviours. Between 2017 and 2022, you had 4 children together. In the autumn of 2022, it is clear you decided that with a 5th child due, you would become itinerant. You then moved between addresses frequently, with the clear aim of ensuring that no local authority would have jurisdiction over you, such that they could take steps to ensure that your 5th child was taken into a protective care. Pausing there. Such behaviour again demonstrates an absence of accountability and deception. You had available to you significant financial resources. Constance Marten, you were the beneficiary of a discretionary trust that provided you with a significant income. There was evidence adduced that over a 4-month period, between the 1st of September 2022 and the 3rd of January 2023, payments totalling £47,886 were made to your bank accounts. A monthly allowance that increased from £500 to £3,400, as well as larger payments, including £13,596 said to be for the purchase of camera and filming equipment on the 17th of November 2022, and £15,590 said to be for the purchase of a car on the 22nd of December 2022. Pausing there. In many instances of child neglect, financial constraints are a sad factor. Here, there was no such financial constraint. The precise details of the birth of Victoria, as you were to name your daughter, are known only to the two of you. It may well be the case that she was born in Woodcutter's Cottage, as you have both claimed, but as much of what you have said at different times cannot be relied on, it is not possible to be exact. Pausing there. It is evident that these two defendants have a loose relationship with what would be regarded as the truth. What is known is that the birth took place before the 5th of January 2023. On that day, the car you were driving caught fire, and when the fire had been extinguished, a placenta was found. When it was found, you had abandoned the car and made your getaway. Not only did you leave the placenta with the car, you left a vast quantity of other items, including baby clothes, a passport, personal belongings, a quantity of cash, more than 30 mobile phones, and a live cat. Pausing there. Abandoning such materials in such circumstances suggests a rather haphazard approach, not only in terms of the material value, but also the usefulness of these items, given the fact that a child had just been born. The fact that the individuals failed to have the birth take place in a hospital is also a potential indicator of a lack of accountability and brings into question the capacity for emotional empathy. Similarly, abandoning a cat is also something that would result in questions being asked about emotional empathy. What then occurred over the following days was that you travelled long distances using taxis, crisscrossing England between various ports. Whatever your ultimate plan, your paramount concern seems to have been to avoid detection and to get abroad, although without any passport for either of you, or indeed the baby, that may have been very difficult to achieve. In my judgment, it is clear that throughout the period from the end of December until your arrest, neither of you gave much, if any, thought to the care or welfare of your baby. Your focus was on yourselves. This supports the suggestion that there are two self-absorbed individuals. Why? We will address that in due course. It's also, again, questions called into being in relation to the capacity for emotional empathy given the failure to provide care or welfare for a newborn child. Back in 2017, you were both given the clearest of warnings about the perils of living with a newborn baby in a tent during the winter months. You had also been warned of the risks of unsafe co-sleeping. A brief review of the history of events with your other children displays an arrogance and lack of thought for anyone else other than yourselves. Whilst you have both sought to paint a picture of being caring parents, both in this court and in the course of the family court proceedings, as even the material set out in the agreed facts of both criminal trials amply demonstrates, the actual position was very different. In June 2017, Marten, you presented at St Mary's Hospital in London. Concerns were raised. At that time, you were 6 months pregnant and had not sought any NHS antenatal care. You were to say that you and Gordon had been living in a camper van which was parked nearby. On the 26th of September 2017, a social services department in London issued a national hospital alert as they had been unable to locate either of you. Later that same year, when in the early stages of labour with your first child, you presented at a hospital in Wales. Marten, you gave the name Isabella O'Brien, and Gordon the name James Amer. Deceit. No NHS antenatal care had been provided. Lack of emotional empathy, potentially. Marten, you told hospital staff you had travelled from Leeds to avoid family. You spoke with a fake Irish accent. You claimed to be from the travelling community and had been raised in a caravan. You said you were no longer in a relationship with the father of your child, and that your family disapproved of a child being born out of wedlock. All lies. You claim never to have been to school, not to have been registered with a GP, and did not have an NHS number. You claimed that Gordon, Amer, was a friend you had known for around a month, but was not the father of the child. Another lie. You said you did not have anything with you for the baby. The lies told indicate the level of deception you were content to practice to suit yourselves. You gave birth to your first child under the assumed identity of Isabella O'Brien, still using a fake Irish accent. Despite what had been claimed, Gordon was the father. Your true identities were ascertained after a social worker recalled the nationwide alert. Police had been called, and they found a passport in the name Marten. You were to tell social workers who attended the hospital that you and Gordon had been evicted from your flat in London and had thereafter lived in a camper van. You also said you had moved to Wales to get away from family, but had struggled with the homeless community there. You said that you had thought that, if you posed as travellers, you would be given social housing. You said you were homeless and did not know how you would meet the needs of the baby in your current situation. You said you were a capable woman and would arrange for housing and state benefits to help you care for the child. You said you had not yet made any inquiries about state benefits and were advised that this was not typically a quick process. A social worker explained to you that social services had a number of concerns, including the falsifying of names, and the two of you had been living in a tent. You had been living in a tent in a wooded area, which, Martin, you said had been your idea. You also said that you would engage with social care professionals and that your child was your priority. When asked if you had any provisions for the child, you said you had some clothing and nappies. You were informed that some baby grows and nappies were simply not enough for a newborn baby to be safe. In November 2017, you were advised to reach out to your family in an attempt to secure housing. As you were claiming to be homeless and there were inadequate preparations for a baby, it was made clear a court order would be sought if you were unable to establish a suitable home for yourself and the baby. An interim care order was made in relation to the child. A number of temporary mother and baby placements were then made. In December 2017, a social worker explained to you, Gordon, that there were concerns about the lack of preparation for the birth of the child. You appeared to accept some of the concerns, but maintained that everyone has a right to choose how they live, sense of entitlement, and that you felt that you and Martin should not be penalised or discriminated against because your lifestyle was not mainstream, victim mentality. A supervision order was made, which allowed the two of you to care for the child under the supervision of social services. That order was discharged in 2018. You then moved to London with no intervention from social services. Your second child was born in 2019. In December 2019, legal proceedings were commenced in relation to the children, with an application for wardship. In January 2020, a local authority commenced care proceedings. Whilst those proceedings were underway, a third child was born in 2020. An emergency protection order was made in relation to that child. The local authority's plan pre-birth in respect of the third child was that on the day of the birth, the child should be placed with you, Martin, in a residential assessment unit with Gordon to join later. A separation order was made in June 2020, as you both refused placement in a residential unit. On the 5th of May 2021, midwives at Sydenham Green Health Centre received a self-referral from you, Martin. You were then heavily pregnant. Appointments were arranged for you to see a midwife and to have an urgent antenatal scan. You did not attend the appointments. You emailed the midwife to say you had decided to have a private scan and would email social services the result. When contacted by telephone, you repeated this account. You never emailed the results of any scan. Deceit. In mid-May 2021, a social worker conducted an unplanned home visit. Martin, you answered the door. You were heavily pregnant. You hid your body behind the door and were adamant that the social worker would not be entering the address. You told the social worker you did not want social services to be draconian and take your baby away. You refused to provide a mobile phone number, and the social worker provided hers. 3 days later, you telephoned the social worker and stated you would obtain private health care for the pregnancy, but would not say where. You also said you planned to have the baby in hospital and that there were no health concerns, so you did not need to share any medical records. You were told that social services required the information in advance to ensure the safe delivery of the baby, and you put the phone down. A fourth child was born at Lewisham Hospital in 2021, at full term with no medical concerns. That same month, the social worker based in Greenwich conducted a hospital visit with both of you. The visit was organised because you had told the hospital you planned to leave the hospital and go to court for a hearing concerning the older children. You were offered a video link to the court from the hospital but declined. During the visit, the social worker explained that the baby was not ready to be discharged and that, Martin, you should be looking after your baby and not leaving that to the nurses who had other duties. Lack of accountability. You both persisted in your intention to leave the hospital. It was explained to you that, if you did so, this would be recorded in the social care record as abandoning the child. You both then left the hospital without the child. Martin, you were told that, if you left, you would not be able to return to the ward due to COVID concerns. Despite that, you attempted to return to the ward the next day, lack of accountability, sense of entitlement, and became upset when refused entry as you refused to take a COVID test. At a meeting with social services in 2021, Martin, you told social services that you and Gordon were naturalists and did not agree with any medical intervention with your child. Delusion, sense of entitlement. I've made references to the care proceedings that started in January 2020, and it was on the 28th of January 2022 that care and placement orders were made in respect of all 4 children. The children were placed with foster parents. At the conclusion of the retrial, the judgment from the proceedings in the family court has been released. In that judgment, the judge sets out her findings that you both presented significant risk of harm to your children. The judge's decision and reasons are now clear for all to see. It is important to note that some significant conduct dealt with in the course of the family court proceedings was not included in the criminal trial. The family court judge described the nature of the relationship between you as being obscure and one that has involved serious physical violence perpetrated by Gordon on Martin that gives an obvious and significant risk to a newborn being caught up in a similar incident. I repeat, that conduct considered by the family court was not part of the criminal trial. The conduct may be relevant to the issue of dangerousness that has to be considered here. What was to take place in late 2022 into the early part of 2023 needs to be seen in the context of the history I have set out, and in particular in the light of the numerous clear warnings given to you both. Returning to the sequence of events, in early 2023, after your car catches fire on the M61, you flee the area before embarking on travelling long distances by taxi, with the travel focusing on ports. The evening of the 5th of January 2023, you are seen in Bolton at the railway station, wearing clothes that are clearly soaking wet. At that stage, other than what you are wearing, you have little, if anything, by way of belongings for yourself, or more significantly, for your newborn baby. You travel to Liverpool. After a very short time there, it is another lengthy taxi to Harwich, where you arrive in the early hours of 6th of January. You are in and around Harwich that day, and in the port area on the 7th of January, when you were spoken to by Dale Gosling. Mr. Gosling spoke about hearing the baby crying. As he was to describe it, it was the cry of a clearly distressed child. Later that morning, you take another taxi to Colchester, before moving to East Ham. Although you claimed the baby was dressed in a ski jacket and normally carried in a sling, where there is video footage, it shows the baby clad in little more than a simple baby grow, and not in a sling. On the afternoon of the 7th of January, Gordon, you resorted to putting plastic bags over your shoes, no doubt due to how wet your feet and shoes had become. You acquired a tent and sleeping bags. A buggy was bought, but soon abandoned before you travelled to the south coast. The taxi driver is told to head for Portsmouth, before then being asked to divert course to Newhaven. You are dropped by the taxi driver just before 5 a.m. on the morning of the 8th of January 2023, and are caught on CCTV heading towards open fields on Cantercrow Hill. The next sightings are some 4 days later on the 12th of January, when you go to a Texaco fuel station. You purchase various items, including some petrol. There are then sightings in Stanmer Park, Brighton, on the 16th of January. The next clear and confirmed sightings of you are not until February 2023. Numerous media releases were made to the public. In February, there are sightings in the area of Hollingbury Golf Course and Seaford. On the 27th of February, a visit to the shops to buy food led ultimately to your arrest. The death of your baby was the result of the obvious neglect by you as to the real needs of your baby. In my judgment, as Professor Havenwith clearly demonstrated through the tests he conducted and presented at the retrial, your baby was exposed to significant cold stress. Clearly, a failure on the part of both parents to look after this child, demonstrating issues in relation to emotional empathy and competence as parents. I propose to sentence you on the basis of a death by hypothermia. Whether it was by that means or by smothering may not make any significant difference when it comes to sentence, but my clear conclusion is that the appropriate basis for sentence, in light of all the evidence, is death by hypothermia. Professor Havenwith concentrated on the first 3 days in which you were camping with your baby between the 8th and 10th of January 2023. He recreated the conditions inside the tent that then existed on the South Downs, as well as the conditions that would have applied outside the tent when you were walking around. He tested a series of different situations. For each of those situations, he was careful to draw on various best-case scenarios relating, for example, to wind speed, body temperature, ground temperature, moisture, damp, and the conditions to which baby Victoria was exposed, both inside and outside the tent. It is of particular significance that he concluded, 1. The insulation available to baby Victoria was insufficient while she was outside the tent and being carried by you, Martin, in the South Downs. 2. The insulation available to baby Victoria was insufficient if she were to have been laid on a pillow under a sleeping bag inside the tent. And 3. Even with baby Victoria being kept next to an adult inside a dry sleeping bag under a dry closed-off coat, and assuming no heat loss to the adult, there would have been just enough insulation to prevent the baby from losing heat and to prevent hypothermia. 4. There would be insufficient insulation if the coat were wet or the sleeping bag was wet. This scenario assumed the coat is kept closed and the baby is not taken out for feeding, comforting, changing, or for any other reason. As Professor Havenwith also explained, and Professor Fleming agreed, once the clothing was opened up to allow for baby Victoria to be changed, fed, or comforted, any microclimate which had built up under the clothing would dissipate. Equally, once the tent was opened, any microclimate inside the tent would quickly dissipate. Even on the basis that baby Victoria was being kept under clothing, during the course of a night or nights spent in the tent, it would have been necessary to change and feed her, and that as a result the climatic conditions to which she would have been exposed would have been worse than the best-case scenarios posited by Professor Havenwith. I am also entirely satisfied that baby Victoria had neither a hat nor a coat. I reject the evidence you both sought to put forward that she was wearing a camouflage baby grow coat. In my judgment, it is also significant that, as Professor Havenwith considered, both the tent and sleeping bags you purchased were inadequate for the climatic conditions at the time. You have both claimed the baby died after just one night in the tent. As I have observed already, the accounts you have given as to what took place are not ones that can be relied on. Lies. You are not seen on any CCTV or in any other sighting after 5 a.m. on the 8th of January until the 12th of January when you make a shopping trip to a petrol station. There was evidence called in both trials of sightings spanning dates between the 16th of January and the 18th of February 2023. Of particular significance are what was seen and heard by Sarah Hidden in the middle of January. Another member of the public saw people matching your description with a front-facing buggy in mid-February. In terms of the date of death, having given the issue careful consideration, in light of the limited definitive material available, I can only be satisfied so that I am sure the baby had died by 12th of January and not a later date. After her death, you concealed her birth, deceit, and perverted the course of justice, deceit. A high-profile and labour-intensive national search and police investigation led eventually to the discovery of your daughter's decomposed body in a supermarket bag for life filled with rubbish and left abandoned in a shed on an allotment. Absence of emotional empathy. When you were arrested, neither of you was prepared to give any assistance to the police, lack of accountability, about the whereabouts of your daughter's body. Your silence at that stage of events is highly significant. If, as you both sought to claim, this was a terrible accident, why not alert the authorities then, and why, once arrested, not say where the body was to be found? You claimed you wanted dignity for your baby's body, and yet your conduct displays the complete opposite. Hypocrisy. In the course of the trial, you have both sought to put the blame on everyone else, blame shifting, on the police for the hunt for the baby, and you. On members of the public, you have claimed some have made up what you said or did in their presence. For others, you suggest all they wanted was their own moment in the limelight, projection. What your attitude completely fails to acknowledge is that it was the safety and well-being of your baby and the two of you that was the paramount concern of the police and members of the public. Had the police not sought to find you, or to make public appeals for assistance, and members of the public not responded by reporting sightings, then many would criticise them for not acting as they should have done. To most right-thinking people, their children are the most precious beings, to be nurtured and cared for, to be kept warm, to be fed, even at the expense of the parents' own comfort. putting the needs of others before oneself, emotional empathy, and above all, to be loved. What you did towards baby Victoria, despite all you claim to have done, can only be described as neglect. Neglect of the gravest and most serious type that led ultimately to her death by your gross negligence. Gross negligence manslaughter is clearly the lead offence. The relevant sentencing guidelines require an assessment of culpability to determine the offence category. There are 4 levels of culpability. On the facts here, this was continued offending in the face of obvious suffering to the deceased, lack of emotional empathy. There is clear negligent conduct in the context of other serious criminality. In addition, there is a blatant disregard for a very high risk of death and the concealment of the body. Those are all factors listed under culpability B. I've taken into account all that has been put forward by the prosecution and on your behalf of this issue. In my judgment, this case is one that falls within very high culpability. Looking at the factors present that I have set out, very high culpability is amply demonstrated by the extreme character of your blatant disregard for a very high risk of death resulting from your negligent conduct, absence of emotional empathy, lack of accountability. There is also the very considerable impact of concealing the birth and perverting the course of justice by hiding the remains of your daughter so as to frustrate a proper examination of the cause of death to hide your own shameful conduct. The conduct occurred in the context of the previous care proceedings. Those proceedings show there had been previous instances of significant failings by each of you towards your other children. Sustained pattern of lack of accountability, entitlement, and absence of emotional empathy. In terms of the repeated warnings given to you, these were from medical professionals and social workers. Those warnings increase culpability and are linked to your blatant disregard to the very high risk of death. You could have been in no doubt that your actions were contrary to the advice given. I have already referred to resources, but you had the financial means and the opportunity to raise your daughter in a safe environment, and you chose not to do so. In my judgment, concealment of the birth, the death, and how the body was then treated really do speak for themselves. The starting point set out in the guidelines for very high culpability is one of 12 years custody with a category range of 10 to 18 years custody. The aggravating features identified may well lead to an uplift to the start point. Moving next to consider any other factors increasing seriousness, in your case, Gordon, there are the previous convictions recorded against you, previous criminality. The older convictions are for extremely serious offences, and the conduct in Wales in 2017 is relevant in the context that the offences relate to events in and around the birth of your first child. In 1994, in America, for armed kidnapping, armed sexual battery, and armed burglary, you were sentenced to a lengthy prison sentence. Those offences date back to April 1989, when you were 14. In addition, there are convictions for armed burglary and aggravated battery from May 1989, also when you were 14. Accordingly, not only are we looking at an individual that has a repeated pattern of criminal behaviour, this occurred at a young age, evidently demonstrating some form of conduct disorder. The facts of events in April 1989 are that you entered the home of your next-door neighbour, a female, through the bathroom window and proceeded to the victim's bedroom. Prior to encountering the victim, you placed a nylon stocking over your face to conceal your identity. You were armed with a kitchen knife as well as a pair of hedge clippers, and after the victim came out of her bedroom to investigate the dog's barking, she came upon you lurking just outside her bedroom door. You ordered the victim back into the bedroom and, still armed, demanded that she undress. You then attempted vaginal intercourse. You held her for a period of approximately 4.5 hours against her will. Lack of emotional empathy. During the commission of the crime, the victim's 2 small children were sleeping in their bedroom. The sexual offending involved the penetration of the victim's vagina with your fingers and tongue, and your penis penetrated the victim's mouth and touched her vagina. On the 21st of May 1989, you entered another house armed with a flat-headed shovel, took kitchen knives and placed them about the house. You found the male victim on a bed, and as he awoke, beat him around the head and body, causing grievous bodily harm. Absence of emotional empathy. On all those matters, you were convicted in 1994 and sentenced to 40 years imprisonment. You were deported to the United Kingdom prior to serving the full sentence. In 2017, there are convictions from the Carmarthenshire Magistrates Court for 2 counts of assaulting a constable and 1 of failing to comply with his sexual offender notification requirements. You were sentenced on the 14th of November 2017 to a total of 12 weeks imprisonment. This incident took place in the maternity ward of West Wales General Hospital. You and Martin had attended the hospital giving false names and identities as Martin was giving birth to your first child. When police attended the hospital and questioned you, Gordon, about your identity, you again gave a false identity, deceit. You then began to pace the room stating that you were confused. You refused to sit down and tried to leave the room. When officers tried to stop you, you assaulted 2 female police officers. You were eventually brought under control after being pepper sprayed and with the assistance of a member of the public who was on the ward. In terms of other aggravating factors, I note what is set out in the prosecuting sentencing note, namely, breach of a relationship of trust responsibility that extends well beyond a duty of care, vulnerable victim, a very young baby, planned and considered offending, failure to heed previous warnings, attempt to conceal evidence, interfere with the investigation, the previous care proceedings, in the case of Gordon, offending while subject to sexual offender notification requirements, and the failure to report your whereabouts whilst the offending was taking place. As a number of these features are ones that have led me to the conclusion as to very high culpability, I must be careful so as to not double count. In terms of the roles you each played, in my judgment, it would be wrong to seek to distinguish. I propose to treat you both as being equally culpable. On factors reducing seriousness or reflecting personal mitigation, Martin, you are now 38. In your case, there are no previous convictions, and I will need to take heed of that feature of the case. In doing so, the conduct and care proceedings is not to be ignored, and, as indicated already, I do not seek to distinguish between the 2 of you as to conduct when it comes to sentence. In my judgment, there has been no genuine expression of remorse from either of you, absence of remorse. Whilst there have been expressions of sorrow about the death, throughout you have adopted the stance of seeking to blame everyone else rather than yourselves for what happened. Blame shifting. With the guidelines on perverting the course of justice, in my judgment, this case comes within high culpability. It is conduct over a period of about 6 weeks where the underlying offences are extremely serious. In terms of harm, this had a serious impact on the administration of justice. The start point on the guidelines is one of 4 years custody and a range of sentence of between 2 and 7 years. If the matter was before me on the perverting alone, in my judgment a sentence of the order of 5 years imprisonment would be appropriate. For the offence of concealing the birth, there are no specific guidelines, just the general guidelines and the overarching principles. The maximum sentence is one of 2 years imprisonment. In my judgment, there is a high level of culpability given that this was done because of the previous involvement of social services. There is clearly a greater level of harm because there is a death. The Sentencing Council guideline for cruelty to a child applies to count 2. Neglect is reflected as part of the duration of the conduct relevant to the sentence for gross negligence manslaughter. I agree with the submission that if looked at alone, neglect that did not cause death would be a Category 2C offence, with a starting point of 12 months and a range of a community order to 2 years and 6 months imprisonment. The neglect was both to avoid the involvement of the social services, lack of emotional empathy, lack of accountability, and follow the previous lack of care towards your other children. These are some aggravating features leading to a sentence for this offence, if being considered alone, that might suggest it would come towards the top of the range. There is no real mitigation here other than lack of previous convictions in your case, Martin, but that must be viewed in the context of the earlier care proceedings. Gordon, in your case, the pre-sentence report is dated 11th of September 2025. It is compiled by a very experienced probation officer. I note what she says about the way in which you were guarded and evasive and frequently deflected direct questions when interviewed. Evasiveness, lack of accountability. I note what is said about your account of the facts. I note that when you were asked about the dynamics of your relationship with Martin, you said you could not answer as you were concerned about information being taken the wrong way. Paranoia. I also note what you say about the future of the relationship between you and Martin. In terms of my assessment of the issue of dangerousness, as well as what is set out in the report as to future risks, I have the advantage of seeing you through the trial and retrial, and also I'm aware of the issues in the family court as well. I have considered what is set out in the summary and opinion section of the psychiatric report. I have reflected on Dr. Farnham's observations in relation to dangerousness. As he states, the question of whether the test is met is one for the court. A further report of Dr. Robert Halsey, a psychologist, was provided to me after the sentencing hearing had started. The report sets out the history he was provided with, some psychometric tests, followed by his opinion including his observations on dangerousness. On your behalf, Ms. McTansey, KC, adopts the position on the facts as set out by Mr. Godfrey on hypothermia or smothering. I have already made clear my conclusion on that earlier in these remarks. She has also reminded the court of matters you set out in your evidence to the jury. Whilst I have had regard to what you said in evidence, the weight to be given to your evidence is limited as a result of your failure to be cross-examined. On the guidelines, it is submitted that it is not a Category A case, and the court is invited to exercise caution as to the Category B features and the need to ensure there is no double counting. On that issue, I have made clear my conclusions. In terms of personal mitigation, reference is made to the reports and the impact on you of the taking away of the other children. You say you regret poor decisions that were made and how things happened. You have said you will live with the consequences of what happened the rest of your life. Victim mentality. It is said you were not thinking rationally and properly, and that your whole life has imploded. Martin. The pre-sentence report in your case is also dated 11th of September. It has also been compiled by an experienced probation officer. There is a very detailed account from you to the author of the report on the facts and the background. On finances, I note that you told the probation officer that you believe you will have access to the discretionary trust in the future and that the restrictions on access may fall away when you turn 40. You also mention another separate trust that you will also have access to. There is a lengthy section of the report on relationships within the family and with Gordon. I do not intend to repeat what is set out in the report as to your observations on the relationships. As I have said about other aspects of this case, in my view, some of your observations and accounts are not reliable. A number of letters of reference have been provided. One is from your stepfather, Guy de Celliers, and another from your mother, Virginia de Celliers. There are also letters from Makisa Robert, Cecilia Robeo, and Sophia Fellows. I have read all of the letters. The authors speak warmly and lovingly of you. There is a psychiatric report from Dr. Bradley Hiller. It was sent to me last Saturday. It refers back to a report he prepared in the course of the first trial. I note in the summary of his conclusions that he says you were experiencing a mild depressive episode within the context of a recurrent depressive disorder at the time of his assessment in August and September this year. He also says that you continue to meet diagnostic criteria for complex post-traumatic stress disorder. He does not consider you meet the diagnostic criteria for any personality disorder, nor does he consider there to be a diagnosis of a substance use disorder. He says you would benefit from an assessment of your sleep function by an appropriate expert. He also says that it is very likely that your CPTSD was present during the period of the alleged offences and triggered by the death of the baby. He also says that your reported behaviour following the death of the baby would not be inconsistent with the process of grief complicated by trauma. On the mechanics of death, Mr. Godfrey invites the court to accept the evidence you gave. He relies on what you were to say in an interview as well as in court. I have dealt in some length with my factual conclusions and for the reasons I have set out already. On sentence overall, Mr. Godfrey submits that there has been remorse and sorrow expressed by you. He submits that from early on you have accepted the baby died as a result of something you did. He submits that your remorse is genuine. I have made my observations on that already. On gross negligence manslaughter, in your case, Gordon, there will be an extended sentence of imprisonment mounting to 18 years with a custodial term of 14 years and an extension period of 4 years. In my judgment, Gordon, in your case, the dangerousness test is met. Martin, in your case, as the dangerousness test is not met, there will be a determinate sentence and a sentence of 14 years imprisonment. In your case, I have given consideration as to whether the custodial sentence should be of the same length as that passed in respect of Gordon. Having reflected on that issue, I'm of the view the custodial term should be of the same length. The issues around future risks have led me to the conclusion that Gordon should be the subject of an extended sentence, and therefore there is a distinction between the two of you. Gordon, what this means is that you likely will serve 2/3 of the custodial term I have imposed. If released at the end of the custodial term, or at the 2/3 point, you will be on licence until the expiry of the extended period of licence. Martin, in your case, you too will serve 2/3 of the sentence I have imposed and then released on licence. If released, you will be on licence until the expiry of the custodial term. Although lengthy, it's worthwhile hearing the sentencing remarks of the judge, not only to understand the background of the case and what these two individuals did, but also demonstrating a recurrent pattern of evasiveness, a lack of trust in authorities, repeated actions of deceit, and of course a considerable criminal history in relation to Mark Gordon. I added, as I went through, observations with regard to issues of entitlement, lack of accountability, lack of emotional empathy, and so forth. You will have heard that in relation to Constance Marten, there is a finding that her behaviour appears to have been driven as a consequence of a mild depressive episode and complex post-traumatic stress disorder. That was a finding made by experts in the context of examination of that particular defendant. Accordingly, on the basis that that is accurate, this then poses the question, what caused a woman who has come from a background of privilege amongst the aristocracy to be involved with an habitual criminal who was involved in violent and sexual crimes? What caused her to fail to behave in an appropriate way towards the care of not just the baby that died, but previous children that were taken into care? Is it something inherent in her? Was it the influence of Mark Gordon? Or might it be a confluence of the two? You now understand the background to the case and the fact that these two individuals are now commencing 14-year sentences in custody. But in the next part, we're going to go back in time to look at Constance Marten and her life to ascertain what might have made her susceptible to this predator's behaviour and to be held in his grip. What might have caused her complex post-traumatic stress disorder, and ultimately, what is Mark Gordon? These factors will help us understand more about how a mother, who ordinarily would exhibit emotional empathy of the highest kind towards a child, failed to do so. Is there something inherently wrong with her, or is this only triggered as a consequence of the influence of Mark Gordon, who clearly is a, putting it lightly, troubled individual? We're going to go back and look at the history of their relationship, the history of Constance Marten, and make an assessment of what brought them together, what kept them together, and what caused the ultimate tragic outcome. Join me in part 2.